On the day, we also heard from Mike Catamol, who is a private client solicitor. Private client solicitor is essentially someone who specialises in wills, powers of attorney and trusts. And Mike was covering inheritance tax and why people should have a will and a trust in place. So, going through some of his slides, first of all, what is inheritance tax and why are we talking about it more today? So, inheritance tax is a tax on someone's estate when they pass away, and it's usually paid when someone's assets exceed their allowances. So in a normal case, that's a nil rate band of £325,000, and when they're passing on property to a relative, that also includes a residential nil rate band, allowing someone to pass essentially £500,000 to the next generation each. So a married couple could theoretically transfer £1 million before there's any inheritance tax due. Inheritance tax, anything above that is taxed at 40%, and there are some examples where people make lifetime gifts above their nil rate band where there's a special lifetime IHT which is charged at 20%. So as many of you know, at Wealth of Advice we help clients to think about wills, trusts and powers of attorney, and that's because we think someone's financial affairs and their legal affairs can be intertwined. So that's why it's great that we know people like Mike and we can chat through client scenarios, so if there is a specialist case he can get involved and help you to think about that more. We've asked Mike to come along because pensions are falling into someone's estate in the future, and again that's going to then mean there's going to be more planning to take place. So as Mike highlighted, inheritance tax thresholds have been frozen for a number of years and they continue to be frozen until 2030, and then the idea from 2027 of your pensions falling into your estate for inheritance tax means that £500,000 figure each might have more fallen into it, and more people would then be impacted by the changes. So, if we jump to why people should have a will, the areas that have been highlighted here are the common ones. So, peace of mind, knowing that your wishes are going to follow you from beyond the grave and that your loved ones can benefit as you intended. That's very important. You also avoid intestacy, which is essentially when someone passes away without a will. This is essentially where there's a set rules on who benefits, and often those standard rules don't match modern family structures. So in Mike's example, if someone had a long-term partner and had children together, because they're not married, they wouldn't automatically leave assets to each other. It would be left for the child, for example. So it's really important just to have your wishes so that it's written down and the next generation sort of knows what to expect from your will. It can be really good for providing for dependents, and it can also be providing for charities. Again, Wealth of Advice have talked about charities that we're supporting, and we've had a number of clients who nominate charities in their will over the years. It's also efficient from a tax point of view, as it can leave a state in a position where they could give money to charities, which can reduce that IHT level as well. So, what happens if someone passes away without a will? We've mentioned the rules of intestacy. Essentially, the high-level view here is that you can have delays because you actually have to go through a legal process to get probate. You can also have family disputes because people can be arguing over what was due to them and what they were expecting to get. But ultimately, you can have a loss of control, and your wishes might not be followed because the laws of intestacy, as I described, might not be the same as what you were expecting to happen. So everyone listening should have a will, and if they don't, definitely get in touch with us and we can help with that process. This is a cautionary tale that we were talked through last Friday. So in this example, we've got David, who's 54, he's a widower, and if he passed away unexpectedly, he had 2 children from his first marriage and a long-term partner, Laura, and also a niece that he had raised as a daughter. In his will, he'd intended to leave certain things, but actually without having a will, having those funds of £600,000, they would be distributed under the laws of intestacy. So Laura, who lived with him, was not entitled to anything as the couple were not married, and his 2 biological children would inherit the estate equally with no provision for Elizabeth, who he wished to leave an asset for. So really, as I said before, it's about having your wishes written down in a legal format in that will so that you can direct what you want to happen with your assets. Planning beyond a will. We heard about trusts, and many of you will be familiar with trusts. Trusts are an old-fashioned concept, and when we think about why they exist to start with, there was an idea of someone going away to a crusade where they would leave their assets to someone, potentially a brother from another land, to look after their assets. And it would be saying, okay, if I don't come back from war, for example, I'd like you to administer to my assets and my estate and keep them going for the future benefit of potentially my wife, who in that case might not have been able to have assets, and children who would be young and unable to look after the assets and the estate. So that concept still exists today in the sense of you have a settler, so that's the person who owns the asset, who appoints them into trust, appoints trustees who can act on their behalf to execute their wishes, and then also nominates beneficiaries. Going forward, for you who have trusts and for people who have talked about trusts, essentially it's the idea of putting an asset in place with your wishes and asking someone to make sure those wishes come true. When we think about the types of trust that there are, there's bare trusts where people are nominated as a beneficiary, but they might be under 18, so they might get control at a certain point, whether that's 18 or 25. You also have discretionary trusts. That's when the trustees have the discretion to pay out funds to a list of potential beneficiaries or a class of beneficiaries. So traditionally this might be to say, I want my children, grandchildren and any future family members to be able to benefit from the trust, and I'm then giving my trustees permission to pay out assets in the future. So why are trusts useful? It's useful for that control, and it's also useful to protect vulnerable people, so those who can't look after assets themselves, or possibly couldn't be trusted with those assets. You're appointed an extra layer of control, and you've got someone appointed there to look after those funds and those assets on their behalf. It can also be really efficient for things like probate, because the asset is not in your estate, it's not waiting for probate on death, and it could be available for those beneficiaries to pay, for example, an inheritance tax bill. So what are the implications of trusts? Well, there are some potential tax rules in relation to trusts. So you can put money into trust, and the ongoing charge is theoretically there's a 10-year charge which could be charged at 6%. In Mike's example, it was talking how super wealthy people could put money into trust and avoid 40% inheritance tax because they're instead paying an anniversary charge of 6% over the nil rate band. When we think about why people should have a trust, there can be particularly useful for planning for the future, for control, and also for the death benefits of your pension, for example. There is a common criticism of trusts where people might say, well, are they expensive? Are there restrictions? And is there going to be changes to rules? In reality, yes, there are setup costs and there are some potential tax with 10-year charges, for example. But actually, the benefits that we see for a lot of clients is the control, the voice beyond the grave, and also the ability to look after vulnerable beneficiaries. So certainly it's worthwhile talking to us about trusts if you think you fall into either one of those categories. Also, in terms of gifting money and it falling out of your estate, that can be an efficient way of putting money into trust, and after 7 years, when it's no longer in your estate, then you've got assets that can be distributed to others, and crucially, it's tax efficient. So when Mike talked through who should consider a trust, essentially, anyone with assets, anyone who is trying to make sure that they leave the nil rate band and the residential nil rate band efficiently could think about trusts. Wealthy families certainly, and then farm owners and business owners was another one who he highlighted, mainly because of the change into their rules, meaning that people in that scenario might want more trusts in place to try and help solve any inheritance tax problems. So to conclude, why should people think about wills, trusts, and also power of attorney? It's because you want to have that thought and have that idea when you're still sort of healthy and still fit in mind, so that you can appoint trustees, appoint executors, appoint beneficiaries, and you can communicate with us as your advisor, so we can make sure your wishes are in those documents. And if we need to talk to the experts such as Mike, we can go through a process and ensure that your wishes are correctly documented and the legal process will be efficient. So I hope you found this bit interesting, and if you have got any specific questions, please get in touch so that we can work through your scenarios.